Stevens Point Historic Preservation Design Review Meeting, recorded October 19, 2022.
Okay, it's 5 o'clock. First order of business, roll call. Mr. Kuhn?
Siebert?
Here.
Monk?
Here.
Christensen?
Here.
McFarland? Here. Scripps is excused. Malevsky?
Here.
And Horag?
Here.
All right, 6-0.
Okay, discussion. Well, first off, the minutes from the September 28th, 2022 meeting. I would entertain a motion to accept. So, Mr. Christensen, Mr. Monk, second.
I have a correction.
Okay.
There's a spot that says motion by Commissioner McFarland to approve the request subject to the following. I believe my motion was subject to number 2 and 3 only, not number 1 of that.
For the conditions, correct. Yeah, 1 should not be on there.
So that should just be corrected.
Perfect. The first condition. So middle of the page on page 412.
Okay. Any other corrections or comments? All right.
I would
Go ahead.
change my motion to reflect that.
Okay. Is that okay with you, Mr. Monk?
Yes.
Okay. All right. Without further discussion, all those in favor say aye.
Aye.
Opposed? All right. Number 3, a discussion on the draft demolition by neglect ordinance. Discussion.
I can give a kind of
Okay, go ahead.
background to start out. So some of you commissioners likely are more aware of the concept of demolition by neglect just based off of how long you've been on the commission thus far. So I'm going to give a kind of a brief background as to what demolition by neglect is and then carry over onto the proposed ordinance itself. So first off, demolition by neglect, how is it defined? It's defined as the process of allowing buildings, streetscape, or site improvements in historic and design review districts to decay, deteriorate, become structurally defective, or otherwise fall into disrepair. And the key feature of this is, situations that by itself does not pose any significant health safety issues right this very minute. But if left unaddressed, it will compound into major issues that will ultimately harm the structural integrity of the building, improvement, or site feature. And that really kind of lends its hand with the intent of this commission by way of Chapter 22, which is shown on the right-hand side of the slide. So examples of neglect, I included some examples in the agenda as well. It's shown on the screen as well. This is not all-inclusive list. There's more that we could rattle off. This is just to kind of give a flavor of what type of situations are we talking about. Deteriorating chimneys. You can see brick literally crumbling away. Cracks in the mortar that over time will allow for water to retain in the brick. And as we see with some buildings already downtown, it's resulting in bricks falling away, the outer layer of the bricks detaching from the inner layer of the bricks. Edgewater Manor is a clear example of that due to our constant thaw and freeze cycles during our winter and spring months. So really, why did we explore a demolition by neglect ordinance in the first place? Now, as the commission is well aware, this commission has reviewed several demolition requests over the years, and really the intent of an ordinance like this is to act as this last safeguard before the thought of a demolition would ever have to be up for discussion. So I know this was discussed in detail, the concept of demoing historic buildings during the Fox Theater discussion a couple years back, and that, at least from my perspective, was one of the driving forces to have this commission adopt this goal as part of your strategic goals last year. So before we get to the heart of the ordinance itself, it's important to really talk about what happens before a demolition by neglect determination is made. And some things that I want to point out first is that, this is a multi-year process. This isn't going to be a case where city staff sends a letter to a property owner tomorrow, for example, saying this building is going is undergoing demolition by neglect, you have to repair it. This is going to be a situation, a multi-month, multi-year process potentially, where city staff is working back and forth with the property owner, where we would let them know what is the deficiency, how does it need to be corrected, what timeline do you have to fix the issue. And this is kind of just a standard flow chart that we have for general code enforcement actions here in the department. You have your initial notice, where the property owner receives the notice saying, hey, this is the violation, you have a deadline to comply. Ultimately, if they work with the respective city official in remedying the situation, case is solved and the case can be closed out. Further developments, if the situation is not remedied, then it would result in fees, citations, municipal citations, thereon and thereforth. And ultimately, at least in conversations with other municipalities as far as how they've adopted demolition by neglect ordinances, there really isn't a set threshold that says, okay, if you're within so many months, so many years, this is when you transition from your active code cases to a demolition by neglect determination. That's ultimately a judgment call on city staff based in part on what is the structural deficiency of the building or site. If that's something that would cause pretty significant peril immediately, then of course, we would have to have that discussion and consultation with the city attorney as well. So initiating demolition by neglect. So again, what I showed before is really the process leading up to that determination being made. Once a determination is made, staff would send a notice to the property owner saying, hey, we believe demolition by neglect is occurring, and there would be this notice that would be sent to them outlining several key facts. What specifically is undergoing neglect? Is it peeling paint? Is it a crumbling chimney, for example? Specific building code and design guidelines administered by this commission that addresses that deficiency and why it needs to be corrected. What type of actions would need to be corrected? And then lastly, deadline to comply. How much time would be served to fix that issue? Ultimately, once the determination is made, that is brought before this commission for review. And this commission would review essentially based off of those 5 criteria that's shown on the screen and in the proposed ordinance. In your opinions, do you believe that neglect is occurring, yes or no? Public hearing would be conducted during that meeting, and then ultimately, as I said, you can confirm or deny whether or not neglect is taking place. Like any enforcement actions, there is also the opportunity for the property owner to appeal the decision, and that's spelled out in here in terms of appealing to the Common Council. So if this commission would choose to say that demolition by neglect is occurring, the property owner would have 2 options. 1, comply with the ruling and remedy the situation, or 2, appeal to the Common Council. And a similar process in terms of the meeting that takes place before this commission or during this commission would also take place during the council meeting as well. And then lastly, after HBDRC and or council review, ultimately there would be this written decision saying this is what needs to be done, this is how it has to be done, this is a deadline to comply, and then it would be up to the property owner working with city staff to make sure that's met. And there are provisions, as I conclude, talking about city abatement of the issue depending on if the property owner fails to meet the deadline, and then also acquisition as well, which I'd defer to the city attorney if he wanted to discuss that. So I guess before we get to discussion, I'll kick it over to Attorney Beveridge if you wanted to outline anything else.
Can you give your name and what you do, please?
Sure, I'm Andrew Beveridge. I'm the city attorney.
Thank you.
So a few things about this. So there's kind of a similar context for this that we see sometimes with non-historic properties. where we just proceed via nuisance actions filed in the circuit court. Now, that's a much more generalized type of remedy, and can cover all kinds of different things. Like the most recent one we dealt with was not even in reference to a structure. It was just a backyard of a property in a residential area in town that was basically piled waist deep with garbage and debris. And the department worked with the property owners over a pretty extensive period of time. Like, for instance, the exhibits I attached to that, I believe, were spanning like 2.5 years of site visits and photographs. And ultimately, we did get an order from the court, but it set a pretty lengthy timeline, and ultimately the place got cleaned up. Now, earlier on in my tenure, there was a nuisance action that was a lot more in line with what this type of remedy is, and it was a house up on North Forest that had been allowed to deteriorate pretty badly, a lot of water damage and just all kinds of things going on. And a lot of property maintenance orders had been sent saying, failure to maintain in a watertight, weather-tight condition, et cetera, et cetera, et cetera. And finally, a nuisance action was filed. And one of the remedies sought was to allow the city to retain contractors to perform the work and place the cost of that on the tax roll. The property owner defaulted on that, and one of the very first things I did, I believe my third day as city attorney, was go to a hearing where our request for a default judgment was granted, and the city did in fact hire a contractor and perform that work. Now, in contexts like that, for instance, just this week, some city staff were helping clean out a extremely dilapidated property on 2nd Street, and what's going to happen there is the property is going to be demolished. Now, it was a difficult one because you had an owner-occupied property, and we had to work with some service agencies here in the community to find new housing for the resident, and then the place is going to be demolished. If that had been a vacant structure, we would have issued a raise order on it a decade ago, possibly longer. So sometimes the solution to a property that's not being maintained is just a raise order, and then you have a buildable lot that presumably somebody could build a new home on. Obviously, historic, different context. We're trying to avoid that in the first place. Now, the number one sort of case study here, and we've adapted this ordinance from the one in Madison. They're kind of they were sort of, leading the charge on creating these types of things in the state. And they had sort of one notable case that happened with it. It was a property on Langdon Street, this historic residential property. And Adam and I have spent a good amount of time just going through sort of the history of how that proceeded under their ordinance. And it was so complicated and so drawn out that you could sense the frustration of the city staff bursting out of the written documents, where we've worked for years trying to get voluntary compliance, and then we bring this forward and the commission's like, let's give some more time. And there's a psychological element to that, which is the staff is at their wit's end working with this property owner, but then the commission is seeing all this for the first time. So to them, doing that feels like giving a second chance, giving a little bit more time. To the staff, it's like, we've done that 15 times. We came to you as a last resort. So sort of independent of the actual structure of this, it would be, I think, a good way to learn from and improve upon the Madison ordinance to have something structurally in the appeals process that takes that sort of dynamic into account. Now, I'm not exactly sure what that is yet. My thinking is still developing on it. Obviously, you have to have some sort of due process mechanism here. But ultimately, as you read these comments from the attorney representing the property owner, they're paying an attorney, they're spending money and time on these appeals, and you almost get the sense that this person is like trying to stave off this like doom, this Armageddon of, if my life will be over if they issue a demolition by neglect ruling. And it's like, no, all it does is mean that the city can then come in and do the work that you insist that you are willing to do if given more time. So it feels a little odd that somebody would scratch and fight tooth and nail to avoid that, when it's like, you say you need more time, but okay, let's just do this. So That's sort of the meta of this, I guess you could say. I haven't said a lick about the actual structure of the ordinance, but we do have a couple of particular properties in mind that we worry about that have triggered this. And in fact, former Alderperson Jennings came to me a couple years ago and mentioned one specific property that I won't mention it on the record here. I could perhaps talk to individuals privately just about that, but we look at some of these properties and we know that they have potentially very, very expensive maintenance issues that you can reasonably suspect will be a challenge for the owners to address. And you hope that when somebody purchases a property of very large size and historic character, that they'd be doing so understanding what they're getting into, but we can't guarantee that. So this is sort of meant to be the backstop for that. And the idea is to use it much earlier in the process of deterioration than we would some of our more generalized building maintenance or nuisance action type proceedings that we look to. So that's kind of my general, really big picture thinking on this. Obviously, we're just doing a discussion today, so this is going to have quite a bit more internal talk between Adam and I to fine-tune this. And we don't have a ton of examples around the state to see how this actually plays out. I mean, like I said, we've got the Madison one, but if we could provide you some of the records of that, and it'd make your head spin how many times it gets kicked back and forth and kicked back and forth. I mean, you can see here. The previous slide, I think it was, can reverse or modify the findings made by the commission or refer the matter back to the commission. That kept happening over and over again. And I think eventually even the commission started to get frustrated with the council, and it was a bit of a circus. But my apologies to the Madison folks referring to it like that. But obviously I can try to answer any questions you have about the nitty-gritty legal details, but they're still in flux. So we're just kind of interested to hear general feedback from you tonight.
I guess to start the discussion, are there any questions regarding just the concept of demolition by neglect, 30,000-foot view, before getting into the specifics of the ordinance and the process therein?
I think the important thing to note is that demolition by neglect doesn't mean the city wants to demolish the property. I think just the opposite, that the city is concerned that demolition is taking place gradually by the neglect. And so I think it's important as we present it to the public that they understand it's not our intent to demolish the product, because that name can be a little bit confusing.
That's actually a really good point, and I think maybe the very first thing that should be said when talking about this topic is, so it is illegal to demolish an historic building. This would make it illegal to allow it to gradually deteriorate.
Mm-hmm.
Just out of curiosity, if the city were to buy it, who sets the price?
Well,
any given property.
So, excellent question. I think that when you have a mechanism in there like that, I mean, that would just be a negotiated price between the city and the property owner.
Okay.
Really what you're talking about with language like that usually is more, we are establishing a legal avenue for which the city can make a purchase of that type, because there's not just a generalized ability for cities to buy and sell property. It has to emanate from powers that are granted under statute. And most of the time you're thinking about just purchases for city facilities or for right-of-way, roads, whatever it is, certain economic development type stuff. So this is getting more at this lever is available to be pulled, and we're putting it in there so that there is something explicit in our code of ordinances that allows for that as an outcome. Otherwise, you start going, do we really have the legal authority to do that? I'm not sure. But you get into some situations where it could be very difficult to establish a price that's fair, because it might have a net negative value once all the deferred maintenance is taken into account. But I think one of the elements that would make a lot of sense to go along with something like this, especially in the context of residential properties, is to, consider the creation of some type of, modest-sized fund to help people out, which, there's obviously, there's grant money that comes from the state, comes from federal authorities. I mean, I'm remembering back, Tim, I know you were on the commission when there was the property on the corner of Wyatt and Main Street, where there'd been some of those exterior repairs that were done, and then the city staff became aware, and they were not done in accordance with the guidelines.
Clark.
Wyatt and Clark, yeah.
Wyatt and
Clark.
Oh yeah, that's right, Wyatt and Clark. Yeah, and that all went all the way to the city council, and they did actually overturn the determination, or provide a waiver in that instance, and that was based upon the financial situation of the property owner, which. I remember I think my dad was still on HPDRC then, and he's a stickler for the rules, and he wasn't real happy about that. But in that type of context, and when we start talking about something like this, where you're not just talking about a delta in the cost of the type of siding or window, where the historically accurate thing is a little bit more expensive, we are talking about a 5-figure bill, maybe 6-figure bill for some sort of repair that a person just literally cannot do. To be able to have some type of funding source would be fantastic. Now, it's easy to say that. It's a lot different thing to actually make it happen. But it would make the pill a lot easier to swallow, because, you're talking about using, the powers of government to compel people to spend very serious amounts of money. So it's not something to be taken lightly. And especially in the context of residential property. When we're talking about the commercial properties, the context changes a little bit. Income properties, nobody's living in them. Well, maybe some tenants are living in them, but it's something for us to consider. And I don't know, offhand, I don't know exactly which pools of money we already have available for those types of purposes.
Yeah, just our facade improvement grant fund, which Clark City Historic District wouldn't apply to, since you can't use that grant just for strict residential uses.
And obviously, most of the downtown stuff are also within the TIF, and there's some possibly funds available within that. But yeah.
I'm curious again. Charleston has probably the strictest rules of anybody I've ever seen. Do you know what they do with somebody who just simply can't afford to fix up one of these historic houses? How Charleston deals with
Charleston, South Carolina?
Yeah.
I don't know. I'm not familiar with a case study of how they do things for historic down there.
Okay.
Obviously, they'd be operating under South Carolina statutes, which could have some of their own wrinkles in them. But this is the first I've heard that there's something of note down there, and I'd be curious to look into it.
I think my concern was basically, as you mentioned, the difference between the downtown and commercial district, particularly that it's in the TIF district too, and residential, which is the historic district, which I am a part of. And I know that I've mentioned that before, just as far as materials. There were some things passed in 13 and 15, right, that made things much more strict, and I didn't even know about it, and I only found out about it because of that house on Wyatt in Clark. And that concerns me too, because it was appealed, and it was passed because that person was determined to not have the money to do it any other way. So what does that put on a person like me? Particularly again in a residential area, because as far as the safety of it and that sort of thing, that's one thing. And I don't know how you would find out whether there's a bulging wall in my house. It's very different, I think, in a residential neighborhood as far as some of these restrictions and requirements.
Yeah, I don't disagree. And, when you start, when you start setting precedent for whether or not these rules will be enforced against somebody based upon their financial situation, it's hard to talk about, equal protection under the law when it's based on a wallet biopsy.
Right.
So, these are the exact policy discussions that come up in the context of almost any historic preservation, discussion at all. And I think the difference here is that we would be looking at this mostly in context where it's not just, well, I'd like to replace the windows or, do some new siding. It's like there's a palpable, significant deterioration of the property that is going to threaten the long-term, viability of the structure as a whole. So it's something where it needs to be fixed, and there is only really one right way to do it. It's kind of independent. It would still be, the repairs to be done would still be through the lens of the guidelines. But we'd probably be starting the conversation talking about more of the bones of the building, water tightness, that type of thing. So these things are going to, no matter what, no matter how well you draft an ordinance like this, each individual instance of its usage, it's going to be a saga unto itself. And you try to take as many different types of scenarios into account ahead of time as you can, but there's ultimately going to be some real hands-on considerations that those types of economic justice type concepts, equal treatment, fairness are going to play in inevitably, and that's why you have these ability to appeal and appeal again, and it's to create a safety valve there, kind of similar to what happens with some zoning stuff, although that's a lot more rigorous than this. But we've all got to be thinking about those things ahead of time.
I guess the other thing is, how is there a point where, particularly again on a residence, how would you even know that there's a structural problem in a house? Or, would you be looking at that when you come around to reevaluate your house for taxes, or what? How would you even know that? Would you enter somebody's house?
So, well, that's actually, one of the issues with this. Obviously, I heard a couple of you talking very briefly about the Fox Theater at the very, prior to the meeting here, and one of the issues that happened there was that a huge amount of that deterioration was kind of invisible, from the street. If you got up above it, you could see that there was problems with the roof. If you got inside it, you certainly knew that there were problems. So it really does come down to, what can you see from the curb? And is that going to tell you the whole story? Obviously not. So there is a very good likelihood that these things are not detected until pretty far along. Now, if an inspector goes to somebody's house for, on the basis of a water heater installation and notices that there is serious electrical, water intrusion, you name it type stuff going on, that's not going to go unnoticed, and they're probably going to start a conversation with the property owner about it. But the idea that you see something slightly off with a property from the outside, and that it's going to turn into seeking a special inspection warrant to go in and check out the rafters, I don't really picture that type of thing happening. Most of these are going to start from, for instance, the Madison one. That property on Langdon Street, very square brick, I think it was Cream City brick, former, luxury home from the turn of the century kind of thing. It had this very interesting porch that wrapped around two sides of the outside of the building, and that was just sagging. You could see this thing sinking, you could see all the woodwork deteriorating, the paint's peeling off, the windows are in bad shape. It was not hidden at all. So it's probably going to be more situations like that where you go by and you just go, oh my goodness, this is not good, what a shame. I can't imagine it being something that would be sort of ticky-tacky. It would be quite obvious by the time we're starting to consider something like this.
I think, too, it's interesting to note Madison's had their ordinance for 5 years. They've only implemented it twice in the 5-year span, and Langdon being one of the two. And that's a community obviously much larger than we are. I think one of the purposes of an ordinance like this is its existence may prevent it from having to be used because people know that it exists and will take care of things. The one thing I did note in their ordinance that I don't see in this one yet is in their fine structure. After a certain time frame, their fees tripled, and they could actually be cited weekly. And so that's how they were able to encourage remediation. And so I don't know, I didn't really notice the fee structure or the intervals or any of that. But sometime after a certain amount of time, that may be something to a component that we may want to consider as well.
Yeah, and we do have that currently in Chapter 22 stating that if a violation occurs, that the city inspector can charge a $200 fee per violation per day that violation occurs. And I know we talked earlier this week in the context of Madison that they triple the amount of fees once in the event that a demolition by neglect determination is made.
Right.
When you have sort of department rules for the frequency of issuance of citations for ongoing property maintenance conditions, whether it's you could see the flow chart up there. It's like eventually hit this stage and then it's the citations issued. Yeah, right there. Yeah, like Adam said, it's actually every day is a separate violation potentially. Now, you're almost never going to see, DJ going by the same property and handing him a citation every 24 hours. So really the point where that daily comes into context would be if my office filed a summons and complaint, which is a sort of long form citation, I guess you could call it, where it's here are the facts that substantiate a violation of this provision of the code. This has been known to be in violation every day since such and such date. Do the math. Times $111.70 is the nominal amount we typically see in our inspection violations. It's been a few years since I've filed one of those, but for instance, we did have a property owner in the historic district. Now this wasn't exterior stuff, it was almost all interior. It was a rental property, a bunch of electrical, plumbing, safety violations. And I think we alleged something that came out to a grand total of, I think it was in the $7,000 to $8,000 range worth of violations. It might have been significantly more than that, but what we put together was a stipulated judgment because the property owner said, I have the wherewithal to do these repairs myself. He didn't have a contractor's license, so he got a contractor's license. We established a deadline, and it was, okay, you're gonna have these repairs completely done by August 15th or whatever it was. And if you satisfy that, we will slash this citation amount by 80%. You're still going to have to pay the piper because you've been failing to even return our communications, and we need to have a deterrent effect here. And he satisfied that. And so it was just a stipulated judgment. The judge approved it, and this was in the municipal court. And he did the repairs and then paid $2,000 or whatever it was, the amount we agreed to. So the daily stuff is really more of like, I'm going to file some 6 to 8 page complaint along with some exhibits and all that stuff. But, only certain situations you're going to want to use like punishment. It's more like, we just want this to actually get fixed. And what's the best way we can address it? Sometimes with traffic court stuff, it's like, you've got a ticket for a suspended license. It's like, I'd rather have you spend the money reinstating your license and paying for car insurance than, paying a forfeiture. But we'd rather have you fixing the roof than paying a fine. So those things could work together. But more often than not, you're going to try to shy away from the forfeitures, at least the really large, holy cow, having to get the calculator out type ones, unless it's needed based on the circumstances to motivate someone.
I'm curious. Oh, go ahead, Carol.
Go ahead.
Kind of along the lines of what Ms. Molesky was talking about. Once we come up with a ordinance, are the owners of the properties going to be notified, sent that, here's all of the criteria, or whatever term you want to use?
Yeah.
They'll be notified so they can't say, well, I didn't know about that.
So if the commission is supportive of adopting an ordinance like this, and when that time comes that the ordinance amendment is up for discussion, there will be the public hearing conducted by this commission. They'll all be notified. They'll receive a personalized letter from me saying, we're going to have a public hearing, this is the reason why, this is the ordinance, you're free to provide testimony.
Okay. So then I've got a property on whatever street, and I'm selling it. So the new person comes in. Do they get notified, or how does that work?
Of the specific ordinance, no. That's in part what Attorney Beveridge mentioned at the beginning, is more doing your due diligence when you purchase a property to make sure that, to A, know that you're in a historic district, and B, what are the ramifications involved in being in a historic district.
I think that, maybe what you should do, and I'm not clear on how it would be different, but perhaps a residential historic district should be different, in the requirements or whatever, than a commercial district, which is in a TIF district. Because as Adam was saying, as far as monies, there's not that kind of opportunity. And I've mentioned here before that when I painted my house the last time, it was $20,000. Now, that is basically 1/10 of the value of my house. So it just seems as though I'm not a commercial enterprise. I'm in a residence. I certainly know that when we started this whole historic district, that we were not, because I was on the committee way back in the 80s, we were not going to be draconian about it, as far as it was basically to kind of keep it intact and not have crazy windows put in, and paint selection would be your choice because that can always be changed. I guess that an overreaching city, I understand it, because obviously I don't want the house next to me falling apart, because that affects my property value too. But perhaps there should be some differentiation between commercial downtown property and a historic district, particularly that there's even a gap between the two. The downtown district, I think, goes down Prentice, right? No, it's not
Rogers
Prentice.
is the farthest east that it goes.
Right. So that section in between there, they decided not to do it, as well as, parts of Main Street way back, which is not the case anymore. But I don't know. Perhaps you could give a second look to that, how that perhaps could be modified. And again, speaking to the financial aspect of it, because these are not million-dollar houses. So the owners of the houses are in a whole different kind of, and it's on a busy street. This is not a secluded neighborhood where all the old houses remain, and a lot of them do, obviously. And it's unfortunately one of the only nice streets with one house after another that's been maintained. So I would hope that there would be some kind of consideration regarding a residential historic district rather than a commercial.
My first thought is $20,000 might be a bargain in the current market.
Years ago or 4 years ago.
I'm not certain off the top of my head, from a statutory perspective, exactly what ability there is to have those types of differentiations, but you're absolutely right in that a historic district is not meant at all to be like a homeowners association dictating your landscaping, and you can't have a swing set in the backyard and that kind of stuff. It's meant to just serve as a preservation of what's already there, exactly the character of up and down Clark and Main that you're talking about. And sort of the use of it we've had over the last few decades, I think, has been appropriate. I mean, the properties have been maintained. Now, granted, most people who buy a house like that, they're buying it because they really, really like those elements of it, so they're going to maintain it. But I think probably, as much as we keep mentioning money, if you have some sort of fund that is, sizable enough to just serve as sort of that gap, cover that gap between what people can afford and what it really takes to satisfy these requirements. But obviously, I keep harping on this. It's easier said than done to come up with funds for that. But I could certainly see just policy merits on having a fund of that type for residential properties, maybe not for the commercial property, especially since, like you mentioned, the facade grant program, that's kind of what that is. We don't really have an equivalent for the residential properties, to my knowledge.
No.
And, I think there's a very good case to be made that there ought to be one.
Yeah, and I agree in terms of providing, or at least having the option of financial means being available in the event a demolition by neglect determination is made. The one item that makes me pause, however, is if it's a grant program or however it's structured, making it structured in a way that it does not incentivize property owners to neglect their property to a state where, hey, I've received a demolition by neglect determination, now I can dip into these funds. So, I mean, it would take some wordsmithing to, take that into account, but I totally agree. I think there should be some financial means that the city could provide, if we can provide it, for residential properties.
There was another question that I had, and I'm kind of monopolizing here, but there's something about streetscape. Now, what exactly does that mean? What does streetscape mean as far as maintaining surrounding environment? And obviously, you mentioned the backyard stuff.
Something?
Yeah, that would be
Fence or-
essentially non-structures located on a historic site. So a fence would be a good example. Like a pergola, granted, you can consider that to be a structure, for example.
Decorative masonry and stonework that's not integral to the structure, that
Yeah.
sort of thing.
So does that mean that if you happen to come into my backyard and you saw that my pergola, I noticed, is just about ready to topple because the wisteria is taking over? So what does that mean?
Hold on, I'm going to need to go call the building inspector real quick. No, I think,
You know what I'm saying? I'm saying that from the time that we created this historic district, there's a creep. There's a creep that now things that are in my backyard are involved,
well, I think the implication, the word streetscape, the street part of that, I think it really does imply what's visible from the street.
Yeah.
And not peering into people's backyards and worrying about sheds and pergolas and that type of stuff. Now, obviously, like if you have a garage that's deteriorating, you might end up getting a notice just on the basis of, you need to do something about the deteriorating garage, but that's a structure as opposed to a pergola or something like that.
So,
But wasn't there something about the look of a shed in a backyard now?
There are design guidelines for
Right.
accessory structures, correct? More so
Backyard.
relating to massing, scale, proportion of the accessory structure relative to the principal structure on the site.
Is that on new construction?
New construction, yes.
so could there be like an addition, like what constitutes streetscaping, to kind of clear that up?
We can do that. We could further define the conditions, kind of do some wordsmithing on, this would be section 4, conditions of neglect. So what are the specific instances that would warrant neglect occurring in the first place? So I mean, that Yeah, I mean, this is really the purpose of the meeting tonight, is to, pinpoint areas that should be worded differently, added, eliminated. So, perfect example. So if you want something,
Yeah, and I also, another thing came up, and I was just wondering if how many of these places in the various districts are landlord tenant are housing for like students or apartments.
Non-owner occupied.
non-owner.
Okay, cool.
Yeah.
I'm
Because
not sure in the historic district.
There's some, but not a ton.
There's like
Because-
2 or 3.
Yeah, because I'm just worried that, if that potential landowner could, say, okay, I'm making X amount of repairs that I'm just going to raise rent for a year or something like that. And I just wondering if there's a way to protect like that kind of relationship, so a landowner can't exploit like a college student, renting an apartment.
Well, if a landlord spends money to make needed repairs to the structure and raises rent in order to fund that, I mean, that's kind of, par for the course. There's a market there. I mean, what you're talking about, it does start to get into ideas of just like rent control, which is a absolutely totally different ballgame.
Yeah.
I'm not even sure if we're allowed to do that in the state of Wisconsin.
No.
I don't think we are.
So non-owner occupied properties, are they considered residential or commercial?
Well, they're considered, so when I'm saying residential, I'm using that in a semi-non-technical or non-technical way. If you have a building that is solely, there are a small number of just like apartment buildings in the historic district. I mean, what's the one on Main Street on the south side of the road? That's the 2 stories.
Stevens on Clark?
There's quite a few of them.
There's
I think.
Stevens, right.
Oh, there's a handful. Yeah, I guess I don't actually know exactly how far east the historic district extends. Is it to like Fremont?
Matthias Mitchell or Design Review District?
Design Review District.
Rogers is the farthest east.
Oh, no, so then the Matthias Mitchell one.
That would be, I
That this is crucial.
think Fremont. That would be Church, essentially. The properties both sides of Strong's. Excuse me. That's the cutoff.
No, how far east it extends.
Matthias Mitchell, Strong's is the farthest east that it goes.
All right, I'm clearly confused. Not the first time. But yeah, when I'm talking residential, I really mean just like traditional single-family home type structures, independent of whether those are occupied by the owner, the renter, or both, as is sometimes the case. But it's just, as opposed to our downtown type buildings or large format churches, that type of stuff.
All right, because I'm just kind of concerned that there's a potential there for a landowner to exploit the situation or somehow burden someone who lives in some of these buildings that don't have who might be just thrown for a loop, on a or something like that. At least, sure. I just don't want a landlord to exploit the situation somehow.
The landlord would be the one responsible for making the repairs.
True.
And would have the financial responsibility, not the renter.
I don't know. I just don't want a landlord to, again,
The cost to repair.
Yeah, to shift it.
They've got a binding lease, so they're going to pay their whatever amounts on their lease,
Yeah.
regardless of what the property owner would have to do for repairs.
Yeah.
And alternatively, if the only way that a landlord is achieving a particular price point is by deferring maintenance and basically eating the capital, so to speak, of the business, I mean, it eventually leads to unsafe living conditions, which obviously has its own downside for the tenants, so.
Okay. Just want to protect tenants, you know, from anything.
Well, and I mean, like, the idea that you, not necessarily through a demo by neglect ordinance, but just by the existence of historic guidelines in general, are making the maintenance of a building, you know, all things being equal, more expensive because there's some particulars you have to abide by. Yeah, I mean, that's certainly something to take into consideration. Like, if you were looking at establishing an entirely new historic district, you know, looking at what is the current proportion of renters that's in this district, how does that fit into our overall housing mix in the community? What effect will this designation have on rents within that district is an absolutely you know, crucial concern that you'd put into that. However, I think that probably just the existence of the historic district in general is going to represent more of an impact on maintenance cost than something like this, which this is like, hey, you really ought to be doing these things anyway.
Okay.
And we just don't want you to allow it to get so bad to where the property is literally unsalvageable, where it's like, it's too far gone, it can't be repaired, and at any reasonable cost.
And I think now, too, isn't Mark Cordes, as he's going around, I mean, there's going to be proactive, and before things get to the point where something like this would need to come into play, they're actually going to be sending out letters just saying, you know, as we're going around and looking, I noticed that perhaps, you know, your roof may need replacement in a few years, so you may want to take that into consideration when you're doing your budgeting and so they're trying to be proactive and give people advance notice and be able to take those things into consideration when they're doing their projecting for the future. So, which I think is a really positive step that they're going to, before it becomes an issue that is a crisis, they're given some advance notice and they're able to plan accordingly.
Yeah, not everybody who owns a building is savvy enough to be able to recognize those things. They're like, oh, it's fine.
Well, and some of them have so many buildings that they might not notice.
We have, since DJ became our building inspector, we've had quite a few more raise orders. And I'm talking about uninhabited buildings, haven't had people living in them for 20 years and have just been sitting there rotting. There'd been a lot of, like, sort of a backlog of those, and we've gotten through maybe half dozen of them in the last few years. And I think, you know, once we've kind of cleared out that backlog of those types of cases, some of those things are coming more to the forefront.
I had one other question, too, a question regarding, and it's in that section 5, and it is 5, way down at the end there. It says, any other factor upon which the Historic Preservation Design Review Committee deems pertinent. That just sounds wide open.
Yeah, I think when we were discussing, it's meant, at least the thought process that Attorney Beveridge and I had was more giving the commission flexibility. If a certain issue doesn't necessarily fall within 1 through 4, but it's still a significant issue nonetheless, that as long as there's grounds to prove that this other factor is warranted, if it's through commission's design guidelines, if it's through other sections of Chapter 22, then that's something that the commission could leverage. I think that's a fair conversation to be had. I totally agree. As to the commission collectively, do you think there should be this subsection 5, this kind of broad factor that the commission would review?
But I think part of that ameliorates that is the fact that you have the right to appeal. So even if a commission would make a determination, you always have that next step. So it's not written in stone either. And so you can include things that you know that if somehow they were misused or abused, that there's still another avenue for the people to pursue.
And that would be touched on, this would be section C, the findings. So commission makes their determination, and then the last sentence, such finding shall state whether demolition by neglect is occurring at the subject property and state the reasons therefore. So kind of similar to zoning board of appeal actions. You make a decision, affirm, yes, no, affirm, deny, but there has to be reasons specifically called out saying why the group, why the commission believes that, why they're making that determination. So that's going to be, the finding section is going to be kind of the meat and potatoes as to what criteria are you using to say whether or not demolition by neglect is occurring. And as the other person mentioned, I mean, there still is the appeal process as well if the property owner believes that that finding is not true to scale, is not representative of what's occurring.
By the way, Adam, just write a quick note for this. Those 1 through 5 factors under that.
Yep.
One glaring one, I just noticed that we don't have it. It does need to refer back to the conditions of neglect explained above under paragraph 4. Like obviously that has to be the main consideration. Mm-hmm. So we need to make sure that it references back there.
Sure.
So I think, but talking about your comment on how general that sounds. So the context of this hearing is what you would call a quasi-judicial process where the board is acting as a fact finder, sort of like what a judge or a jury would do. And when you have words like deem pertinent, that's really getting at, it's indicating that there has to be an exercise of judgment there that has basis in the standard and the evidence that's being brought forward. So it can't be like, well, the property owner got into an argument with my mom 5 years ago, and I'm deeming that pertinent. No, that wouldn't fly. So you're right to point out like that seems like kind of like weasel words, deems pertinent. But I think because of the context of this being sort of a quasi-judicial thing, I think it actually does have guide rails around it. It would need to be something that's relevant to the overall purpose of the statute, relevant to just general principles of sort of justice and fairness and all those types of concepts.
So maybe there should be an extension on that line of pertinent to.
Yeah, we could certainly elaborate on that a bit more to flesh it out further. Yeah, we could absolutely do that.
Okay. Any other comments, discussion
On the
points?
last page here.
Oh dear.
What do we currently have in place so that a homeowner will not take advantage of a budget that's set for certain repairs? Do we have anything currently in place so someone couldn't wait 5 years till they get a neglect order? And
So, as I mentioned before, we do have the facade improvement grant program. I'm trying to think offhand if there's a specific, like in the eligibility criteria, if it specifically calls out, say, like a self-created hardship claim, that wouldn't be eligible for funds. I don't believe so. Unless you can think at all, I don't believe.
Yeah, so the phrase self-created hardship that Adam just mentioned, that was in the very last round of emails he and I exchanged. And that's a phrase that largely comes up for the two of us when we're talking in the context of zoning variances. So if you buy a piece of property and have certain designs and purposes for it, and what you want to do just doesn't fit on it, like you bought this with a plan to build such and such type of business, and it just doesn't fit there, and you go, oh, I need a variance because I can't execute my plan here. And we say, well, you created that hardship by improperly evaluating how much space you needed, that sort of thing. Or somebody just like goes ahead and builds something, and then they find out that the setbacks aren't met. And they go, I have a hardship because I'd have to take this building down. Well, it's like you created that issue yourself. So in those types of contexts, it's fairly easy to identify, and there's a lot of elaborate case law history that says, this is what a self-created hardship is. I think here would be a lot more tricky, actually, to, is somebody sort of sandbagging these repairs and then going, oh, it's reached this point, open up the piggy bank for me. Well, I would expect that if we did put together any sort of program to assist people with repairs, it's going to be in a similar form to what you see with the facade grant. It's going to be a matching grant type of thing. So it's not like somebody's going to get something absolutely for free. They're going to get some assistance, a reasonable amount of assistance to bridge a gap. So if you're still going to be on the hook for 60, 70, 80% of the cost of something, it really behooves you to get it on top of it sooner so that that overall cost of it is smaller, rather than allowing it to balloon and things to rot and more materials to deteriorate. So if somebody tried to play a game like that, they're probably just playing a losing game. And since this is going to be sort of this backstop last resort, there's going to be a history of communication between the staff and the property owner leading up to that. And it's very likely that if there was any sort of intent like that on the part of a property owner, that it would be borne out in that history of communication with them.
I guess generally speaking, is there interest amongst the commission to have financial assistance, a financial assistance program be coupled with not necessarily demolition by neglect ordinance, but in the event a determination is brought before this commission to confirm or deny that there's also this financial mechanism in place that folks could tap into.
Similar to the facade grant.
Yeah.
Similar to the
possibly
facade
or
grant.
matching, because there's still a responsibility of the homeowner here in all of these circumstances. Again, the financial thing, but you let it go for a decade, of course the bill is going to be greater than if you would have addressed it at year one.
Okay.
So.
And I think here's where I have to be a little fussy. I think us discussing to a certain extent a financial mechanism fits within the confines of this agenda item, but for us to start to get more elaborate into the mechanism of what that might look like, I think we're starting to run a little far astray of what's on the agenda.
Okay.
So would be happy to bring that back for a much fuller discussion at a later meeting.
Perfect.
And I think what goes with this, and I've brought it up before, I think the commission really has to look at materials, because I know that as it is right now, I have to put wood siding back on my house, and I would have to have it planed, because it's an 8-inch reveal, and I can't imagine how much that would cost. So I did mention a while ago, probably a year and a half ago, that I think that the commission has to look at materials, and this relates to people who are having to repair their buildings on this kind of, demolition by neglect, that they have some options as far as affordable materials to fix their property.
Yeah, and that was something I brought up last meeting, where sometime this later fall, winter is when I plan to kind of have some kickoff meetings amongst the commission where we do a deep dive of our design guidelines and see what works, what doesn't, what needs to be revised. So it'll be good.
It was interesting, that same lady from Madison was talking about, they actually allowed smooth, was it LP siding, or I'm trying to, there was one of them.
Smart siding, sure.
But the smart, but they're no longer, this is the last year that they're producing the smooth, they're only going to have the wood grain.
Yeah.
And so one of the few alternatives that was a little less costly that they had approved, because the look was so similar, is no longer going to be available. So
The materials are going to be a hard thing because they change so frequently.
Any other comments or specifics about the ordinance that you'd like revised or like us to take a look at further?
yeah, if you can give us that revision by tomorrow.
Thank you, Alder Christensen.
As long as the power doesn't go out again.
Yes, the power doesn't.
I have just a general question. Is this more aimed at the city being able to acquire some of these properties? Or is this simply we want to help these people and make it known that they have some issues to repair themselves?
I think that the city acquiring a property would probably be the most extraordinary circumstances.
Okay.
And most likely, the city acquiring a property would only be in the context of the downtown, where it's in conjunction with a broader economic development principle, where this just would be one little part of the puzzle, would be my expectation.
What was the result of the Madison case? Was that was a lien put on their taxes annually for 5 years? Or how, do you recall how that was? And then,
Well, I just know the ultimate outcome was it got repaired.
Okay.
Yeah.
I was so focused on the process, I was like, outcome, schmoutcome, like,
Yeah, 'cause
process here.
their landmarks commission confirmed staff's determination. Their council confirmed their landmarks commission's determination. I don't believe the city went in and abated it.
I don't think so either.
I'm going to be down there on Friday. I can roll by and take a photo and no, tell me.
And they did get fixed. She actually included
Yeah.
photos,
Okay.
and it was pretty impressive. I think the big thing is they feel that there's a public value in these historic buildings, and they're just trying to preserve the public value. And so even if the private individual needs some encouragement, they think that there's something that the community would lose if they allow it to just
We have a
be
perfect
neglected to that point.
We have a perfect case study example of that, the Claflin House. That was so close to being raised. Like, our inspectors, when they were in there in like 2018, would not enter certain areas of the building because they were afraid that they would go through the floor. And you think, first of all, it would have been great if we would have been able to get on top of compelling an owner to keep the water out earlier on. But also you think, you know, think what would have, the opportunity that would have been lost if it would have been torn down, so.
Yeah, I think I mentioned it in the packet. I do believe that, you know, if an ordinance, however it's structured, is adopted, and, you know, you have years to really see the fruits of this commission's labor, that the quantity of demolition reviews that's brought before this commission should be very slimmed down, if not non-existent, just because demolition by neglect is the last resort. You know, if somebody comes in with a demolition request before this commission and they claim that the structure is in such disrepair, my perspective, likewise I'm sure all of your perspectives are, then why don't we consider demolition by neglect? That will at least save the structure before we ever have to have a conversation about demolishing it.
Just the fact that Madison has had only 2 in 5 years since its inception, and they're how many times our size? It should be something that we very, very rarely use, but the fact that it exists almost will make it less likely that it will be used as well.
Yeah.
And I think a bit sadder case study, I think if we would have had one of these on the books 20 years ago, I think there's a very good chance that right now you have a restored, functional Eagle Plumbing building sitting at the corner of Portage and 3rd.
Yeah. Yeah.
There was just one other comment I was going to make. You had the house before you at 2101 Clark Street last month.
Yes.
And the reason really that that's still intact is because the senior Blinker bought it and basically shored up all the porches because they were falling off. And he said the only way that this could have been done in any kind of reasonable manner is because he was a contractor, because they were falling off. And so thus, obviously, a relative of the original builder lives in there now. And he had that all done. They redid the plumbing, everything, you know. So I can't imagine what the expense would have been to keep that, as particularly when they have the carriage barn there, you know, where they kept the caissons for the funeral home. That building would have been gone had it not been for Mr. Blinker.
Did you say 2101 Clark Street?
Mm-hmm. It's it was the greenhouse on the corner.
Corner, it would be
Oh, the one that's getting
By Emerson.
redone in the
Yeah.
exterior right now?
Yeah,
Yeah.
southeast corner of Clark and Reserve.
It was a Boston home.
Yep, looks.
Oh, okay. Yeah, that place is amazing.
I'm talking about the wedding cake house.
No,
No, it's right across from Emerson.
right, overlooks Emerson Park.
Okay,
Putting
okay.
on new
I
stuff.
was actually thinking of that property earlier in the discussion, because when you talk about streetscape, one of the reasons why we allowed the windows to be put in where we did was the fact that it's not a front elevation, and in that part of the ordinance, it states to whether or not it's on the street elevation or not. And streetscape is kind of a similar type of concept, where if it's something that's visible to the public as they're driving by, then you do treat it differently than others. So it's not uncommon for that front elevation and the front portion that is visible from the street to be treated differently than the rest of the property.
Which obviously we do in the context of zoning too,
Yep.
so.
Yeah.
Yep.
Okay, I think this is extremely
Good discussion.
helpful. So next time we meet, I'm assuming probably sometime before Thanksgiving, maybe the week before Thanksgiving, the week of Thanksgiving, we'll meet up and we'll have another draft before you.
Yeah, and I'd like to make some phone calls around and see what the experience is down in Madison or elsewhere with something like this in the context of an owner-occupied residential property.
Yeah.
Is that, the case study we looked at from down there, it was a rental.
Yeah, as we can touch base maybe next week.
Okay.
Yeah.
We are adjourned.
A video of this meeting is available for viewing on the city's website, stevenspoint.com/videos.